Officer Dade, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We are on the record. We are calling case number 2015579. The case is entitled Open MRI of Livonia. In DBA Live Open individually and as assignee of Roderick Vaughn versus Liberty Mutual General Insurance Company and Liberty Mutual Insurance Company. This is the date and time for a motion for summary disposition filed on behalf of defendants. Could I have your respective appearances?
Good morning, Harold and Beverly, P44028 on behalf of the plaintiff.
And good morning, Tom Zaguris on behalf of defendant Liberty Mutual.
You a member of the State Bar of Michigan?
Yes, P74836.
Your motion.
Thank you, Judge. Today is our motion for summary disposition. It's a very straightforward motion. The claims being brought in this lawsuit are open MRI for patient Roderick Vaughn. Roderick Vaughn had his own lawsuit in Oakland County. The case went to arbitration in February of 2020 and settled for $167,500. In the arbitration award, Roderick Vaughn releases all claims prior to October 2019, October 16, 2019. Roderick Vaughn signed a release releasing.
Stop right there. I thought he released all claims with the exception.
He released all claims prior to October 16, 2019, with the exception of 3 providers that were spelled out as Michigan Muscular Institute, Maxim MRI, and Orchard Toxicology, none of which are open MRI.
That's a fair point. But you said he released all claims. That's factually inaccurate.
Well, I was gonna say it, but I wasn't there yet. He did release all claims with the exception of 3 that are not the plaintiff here today.
So for other provider suits served prior to October 16th.
Correct.
Go ahead, sir.
Thank you, Judge. The claims at issue in this lawsuit, the dates of service at issue are for, it's MRIs on May 28th, 2019 and June 1st, 2019. So both claims at issue are from in the time that he released the claims, and the assignment plaintiff was signed after the release. There's no benefits available. The claim was owned by Roderick Vaughn at the time he signed the release, and he released all the claims. Plaintiff has no basis for recovery.
Plaintiff's argument is that there's been a statutory amendment, and that under the amended version, which came on after covenant, the provider has a direct cause of action. What's your response to that?
My response to that is we're not challenging plaintiff's standing to bring the lawsuit. Plaintiff has a provider can bring a direct action. In this case, there's a release where the person who owned the benefits released all benefits. Plaintiff has there's nothing to recover.
Let me hear from the other side.
Well, plaintiff disagrees. First of all, they knew of the, they knew of the 2 scans more than a year before they settled the claim. And the appropriate thing to have done, since they knew of the claim, issued an EOR, which says that they were suspending the benefits per, some other reason. They acknowledged they received it. They communicated. Now, what happened is, and what's happening with a lot of this particular defendant is they get over in circuit court, they do an agreement, and then they have them, sign documents. When the appropriate thing, when you have all these providers out there and you've issued EORs, you're aware of the claims, is for you to file a motion for apportionment and have the first party benefits divvied up by the circuit court judge. But that's not what Defendant Liberty Mutual is doing.
Okay, let's assume that that's appropriate. Is it not also appropriate for your client to intervene into the circuit court action?
My client had no knowledge of the circuit court action. Absolutely no knowledge.
Your office was not involved, didn't represent Mr. Gordon in the circuit court action?
No,
Okay, please continue.
we weren't there. Therefore, there was, there's no privity or anything of that matter. We should have been there. We didn't know about it. No one told us about it. They knew of our claim. So the new thing with defendants is to pick the defendants or pick the providers that they want to exclude from the releases. That's not how it's done. You had notice of it. You should have given it. We have a direct cause of action against you for that.
Okay, let us assume for purposes of our discussion that the amendment to 531.12, as it says on its face, gives the provider a direct cause of action. How do you deal with the safe harbor provision, which says, hey, if you've made a settlement in good faith, you're done?
Oh, that's not good faith. There's
case-
absolute.
And in this case, the release specifically provides that the plaintiff, the injured individual, would indemnify any unpaid bills. How was your client prejudiced by that?
My client is prejudiced because they could go to him and get the money back if they have to pay it out. Let's not put all this on the plaintiff, which is what some judges and some courts like to do. They have a responsibility to deal with all of the providers. You can't just go and say, hey man, I'm going to give you $167,000, but I want you to get rid of all these other ones. You can't do that. You're cutting the legs out from the providers, and that's not fair, and it's not what's called for under the statute. And if you have providers that you're not sure whether or not they want to be paid, then you need to do a motion for apportionment in circuit court. There's no way, as a plaintiff's counsel, if I had all these people out there, I wouldn't do that. You chose not to do it. So on the back end, since defendant chose not to do it, they need to go and get their money from Vaughn, but they need to pay their providers. And I'm pretty certain I have some other, by the way, assignments. That just happens to be the one that was attached at that time.
Let me hear from the other side.
There's a lot to address, but I'm going to try to be brief. It's really not relevant. There's been nothing documentary or legally to set aside the release. I've heard defendant doesn't have any burden to call every provider and tell them of an arbitration. Plaintiff's bills were from June of 2019. We have 30 days to investigate. After that, they could have brought their lawsuit for 6 months before the arbitration. Plaintiff Roderick Vaughn filed a lawsuit for all no-fault benefits, and he released all no-fault benefits. And this MRI was a claim that he had. Roderick Vaughn was aware of the claim. They went to arbitration. They've had their opportunity to present all the claims.
The assignment, as I understand it, was made on June the 4th of 2020. Is that accurate?
Yes.
Your Honor, this last service was on June 4th.
No, I'm asking about
2019. I know, and
That's
I'm
inaccurate.
certain. I know that there are assignments, I believe. I hope I'm not mixing my cases up, that are closer in time.
The only,
if you would, sir. So here's the problem that I have. Even if I accept your arguments, Ms. Beverly, the cause of action in favor of your client could not have been created prior to the execution of the assignment.
Not so, only with the assignment.
That's the point I'm making. If the releases for the arbitration agreement, which release all providers except certain named ones who y'all now agree do not include your client, was signed on May 15th of 2020. And the assignment from the plaintiff to your client took place on June 4th. Then at that point, as I understand the time sequence, the assignment to your client came after the resolution and the release in the arbitration matter. Is that factually accurate?
For that assignment, I cannot disagree with that, but I do think that there are earlier assignments in the
Okay.
available.
All right, are there anything, is there anything else anybody wants to say?
No, Your Honor, thank you very much.
The only thing I'd like to say is that we do have a direct cause of action, and I don't believe that there's anything that provides that we have to do it in any other time period other than before the end of the statute of limitations, and we were well within our statute of limitations. We did not know of any other suits out there, but Defendant Liberty Mutual knew that we were out there. They issued an EOR, and I don't think that there is anything that they have shown here to indicate that it was a good faith settlement, knowing that we were out there.
I'm prepared to rule on this matter. The matter is before the court on the motion of the defendants claiming that they are entitled to summary disposition by way of release. The court has heard the arguments here, and I've had the opportunity to review the pleadings filed on behalf of both defendants. Significant to me is the language of the release that was executed on May 15th, 2020, a release which was apparently executed prior to the assignment to the plaintiff in this matter, which was executed on or about June 4th, 2020, roughly 15 to 19 days later. In that release of claims, entitled Release of Claim for Personal Protection Insurance Benefits, the injured individual, Mr. Vaughn, says he's releasing all claims as relates to the automobile accident of February 7th. I am specifically releasing all claims I have against LM General Insurance Company for past, present, wage loss benefits, medical benefits, and any all benefits to which I may be entitled under the provisions of the Motor Vehicle No Fault Act incurred through 10/16/19. I further agree to hold them harmless for any liens or demands from any other provider. Then it goes on to say this release is not covering claims from the following specific individuals or providers, none of which are the plaintiff in this matter. I am of the opinion that in this factual situation, the plaintiff, in essence, took an empty poke from Mr. Vaughn when it took an assignment on June 4th, 15 to 19 days after the release in the other matter. The motion for summary disposition filed on behalf of defendants on the basis of release will therefore be granted. Anyone who disagrees with my opinion, of course, has an absolute right to appeal my decision. That appeal will be perfected in 21 days of today in the Wayne County Circuit Court.
Your Honor, we have 2 counts in our complaint, and the other is a direct cause of action.
Counsel.
In response, same argument, the release still applies. While they may have a right to a direct cause of action, there's nothing to recover as Vaughn held the claim at the time he released it.
I agree. He had it at that time. So I'm going to grant a motion for summary disposition on the basis of prior release.
You're going to grant on the direct claim.
I'm going to grant summary disposition in total, correct? You have an absolute right to appeal my decision.
Yes, I know.
Effective in 21 days of today in the Wayne County Circuit Court. Thank you both for coming in. We're now off the record.
Thank you, Judge. Do you want our office to submit an order?
I have the judgment form right here. I'll just do it on the basis of summary disposition.
Thank you very much.
Thank you both for coming in. Have a good Okay, it's done. That's the end of that. My next file is until 11 o'clock. Good morning.
Good morning.
Good morning, Your Honor.
We are on the record. We are calling file number 20156-539, Security Credit Services versus Danita McQueen. This is a pretrial. Your respective appearances.
Good morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
And what is your name, ma'am?
I'm Danita McQueen.
All right. We have had it. This is our second pretrial, correct? Where are we on this file?
Your Honor, we sent written discovery to Ms. McQueen. She didn't answer. I just request a hearing date for a motion for summary disposition at this point.
I'm sorry, have you filed such a motion?
I have not, Your Honor.
Well,
But
why don't you file it?
Okay.
And we'll move forward. Ma'am,
Okay.
are you planning on doing any discovery in this matter?
My only concern is they sent me, because last time I asked about this, they sent me this contract. This is not my signature. So I need them to show me something with my signature on it. I have several pieces of ID that are old, past this date. This is not my signature. Now, I don't have a problem with paying anything that I owe. I've been in the past, have been, had identity theft. I've had to put a flag on my social security number. I just need them to show me something with my signature on it. I'm not trying to shy away from anything. You show me a contract with my signature on it, we can talk.
Okay. Ma'am, if you want to file a discovery request, you have a right to do that. So we'll see.
How do I do that?
How to say this? The Michigan court rules provide ways, ma'am, that you can seek to obtain written information from the other side. You have to follow those rules. I cannot tell you what to do. I can't give legal advice to either side in litigation. Does March 5 work for both of you for our next date?
Just a second.
It's a Friday like today.
That works for me, Your Honor.
What about you?
Yeah, that's fine.
All right,
March 5th.
March 5 at 11 o'clock. Your written discovery will remain open until March 5. We'll get you an order. We'll see you again March 5 at 11 o'clock. Let's
Okay.
get our discovery rolling here. Is there anything else we can accomplish today?
This will also be Zoom, correct?
Yes, ma'am. It'll be. I don't anticipate the court being open for civil matters this year, ma'am, quite frankly.
I got you. Okay.
Anything else?
All right. I'll figure out what to do on my end. No, I'll try to get some legal help on my end. Thank
On
you.
the Michigan Supreme Court website, they have copies of Michigan court rules there, ma'am.
Okay. Thank you.
All right, y'all have a good day. We're off the record.
You as well.
Your Honor, you too.